Hello, my name is Paul Sorkin. I am an intellectual property portfolio manager here at the MIT Technology Licensing Office, often referred to as the TLO. I have a technical background. I am a patent attorney, and I've been here as of today about 2.5 years. It's a really interesting role for me, to the junction of creativity, the work that's being done. Here at the TLO, we're involved in working with many principal investigators, and our goal is to get their creations out into, use for society to benefit therefrom. So I was going to talk today somewhat about intellectual property. Consists mainly of, you've probably heard, patent, copyright, trademark, and trade secret. Intellectual property allows a creator, an author or an inventor, composer, musician, even a dance choreographer, to attain legal protections for their creations. In this way, they're able to control how their creations are used so that they're not abused by others. The intellectual property is similar to real property in that it can be sold, conveyed, licensed. It can even be inherited or used as collateral for a loan, for example. Think of intellectual property as almost very similar to real property, generally like land. But by providing protection, intellectual property protection, this incentivizes businesses, inventors, creators, authors to make these creations which benefit all of us here in society. Otherwise, there might be less interest in investing in new technologies, investing in an artist. As I said, there's 4 main types of intellectual property. There's trade secrets, trademarks, copyright, and patents. So a trade secret is often used to protect confidential business information. The key word here being secret. In order to maintain the protection, there have to be efforts put in place to make sure that the publication of the secret information is closely controlled. Anecdotally, many of you have probably heard about the formula for Coca-Cola brand soda that is unknown, and that maybe there's only 2 people in the whole world who know the formula, and it's kept in a vault so that it can't be divulged. The thing about trade secret is that if someone were able to reverse engineer, that is, like take the product and try to figure out what all the components are, you might lose your trade secret protection. So again, the elements for a trade secret to protect something that is valuable, that gives one a commercial advantage over another, it's got to be kept secret. There have to be significant efforts put in place to keep it secret. Unlike other intellectual property, a trade secret can last forever, but is only as good as the efforts put in place to keep it a secret. So it's definitely a trade-off. In the university area, there aren't that many disclosures or discoveries that are kept as trade secret, mainly because of the efforts that are required and where most universities are required to disclose or publicize what they've been worked on. So there are some trade secrets for universities, but not many. So the next type of intellectual property is a trademark. And this is something that most of us are familiar with. A trademark is used to identify for the consumer the source of goods or services. We all have our favorite brands, whether they're jeans or shoes or jackets, etc. And the trademark is what allows the owner of the trademark to distinguish their products from another. Issues as to quality, brand loyalty, etc. So with a trademark, once one has a trademark, you have to work pretty hard to make sure that no one else is using your mark. similar to the efforts that companies like Nike and Apple make sure that no one is using the swoosh or the half-eaten apple in commerce for athletic shoes or computers and devices like that. In order to attain a trademark, it's got to be distinctive. It has to be like non-descriptive, something that's either fanciful or made up. And it has to be used in interstate commerce, especially to obtain a federal registration, which we often see with the R inside a circle. Trademarks can last forever. They just have to be in continuous use, and you have to show continuous use. Institutions such as MIT do have trademarks, which we do license out for items such as hats and mugs, etc. And we do police and make sure that others are not using our marks in ways that we have not approved. Copyright. Copyright protects creative works such as books, music, recordings, dance, architectural drawings, as I've said. The requirement is that it be put into a fixed medium. So copyright protects the expression of an idea and not the idea itself. As an example of copyright, the Harry Potter series of movies and books, those are copyrighted. However, the idea of a school that teaches magic or a school where the students all have magic powers, that idea in and of itself is not copyrighted. It's the expression of a story about a wizarding school. A patent is issued to an inventor to cover their invention with whether it's a method, an apparatus, a composition of matter, or the like. It gives the inventor or the owner of the patent the right to exclude others from making, using, selling, or offering to sell the patented invention. It's a negative right in that the gist of the protection is that you can stop others from practicing. Like most intellectual property, a patent can be owned, it can be sold, inherited, pledged as collateral, and licensed, which is a not insignificant amount of activity with respect to patents. Many institutions of higher learning or education, such as MIT, and particularly the role of the Technology Licensing Office, the TLO, is to obtain patents and to find licensees who are willing to commercialize the technology and bring it to market for the benefit of all of us. The criteria for obtaining a patent is that it has to be novel, in that it's never been done before. It has to be non-obvious. In other words, it can't just be a minimal change from what is already known, which is often referred to as the prior art. And it has to have utility. It has to do something. It can't be non-useful. And a patent application is submitted to the patent office and is reviewed. And when it's determined that it does define a patentable invention, then a patent is granted. A patent in the United States is good for 20 years from its original filing date. However, it may take anywhere from 3 to 5 years or longer for the patent to make its way through the Patent and Trademark Office to be reviewed and verified. Once it issues, then the remaining term would be from the date it grants to the expiration of that 20-year anniversary. In the United States, a patent is kept in force by the payment of maintenance fees, which generally occur every 3.5 years, up to about 14 years of term. If a maintenance fee is not paid, the patent is abandoned and its subject matter falls into the public domain for anyone to use. By definition, the inventor is the owner of a patent. If there are 2 or more inventors, then they are joint owners. Most often, however, because an inventor may be working for a company or for a university, they assign their interest to the company or the university, and that entity then becomes the owner of the patent. The individuals will always be the inventors. They just may not be the owners of the patent. Patents are often the subject of licenses, especially in higher education. Technology Transfer Office, such as the TLO here at MIT, will work with licensees. Oftentimes they may be startups who come out of our ecosystem who are interested in obtaining the rights to the technology that they may have been working on either as a graduate student or a postgraduate student here at MIT. So we work to help them obtain the licenses that they need and hopefully move on to be successful companies.